Hey guys, in the case against Brian Coburger, public knowledge of the evidence, it's pretty limited, right? So far, we have what was used to establish probable cause for the arrest and the searches, what was returned on the searches, and some bits of things contained in filings as the parties spar over discovery and stuff like that. In addition to the circumstantial evidence supporting Kohberger's arrest, which was used so far to meet the probable cause standard, we've learned the DNA sample from the knife sheath found at the scene under a murder victim and a comforter contained DNA from one source. That's the state's contention, and that's Brian Kohberger. We also have the defense contention that Kohberger's vehicle did not contain evidence linking him to the vehicles, and that's a good point by the defense. Now, what happened at the scene is they didn't find a K-bar knife. This is an example of that. There's lots of different kinds of K-bar knives. There's not just one. But they did find the sheath at the scene. This isn't like that because the one they found at the scene is the leather one with the Marine emblem on it. And I wasn't in the Marine, so I'm not buying stuff with their logo on it. But it's a cool sheath, a lot of history behind it. They find that at the scene. And what they found on it was DNA on a snap. So here's a snap right here, right? Now, you know, when the thing is in the sheath, you don't have to mess with the snap to get it out. You just flick it, right? But when you're putting it in the sheath and you don't want it to fall out of it, because that's what would happen if it got turned upside down or something, you need to snap it. And to do that, you have to do what I just did, which is press down on it. And that could leave, I suppose, potentially a print, but also potentially some DNA on this metal surface. And that's where they recovered the DNA at. So finding somebody's DNA on the sheath that apparently held the murder weapon and finding that sheath partially under the murder victim, that's bad news for the defense, very bad news. Now, one way to contend with that, at least on social media, is to simply announce that touch DNA is bogus evidence. And that's exciting for people with extremely limited intellect because it's at the slogan level, which is what their brains can process. And it lets them pretend they have an understanding of something that's actually really in real life complicated, and lets them pretend they have a galaxy brain that allows them vision to see so much more than the entire judicial system, the entire field of forensic science, and the entire science regarding DNA. There are people like that. Of course, on the other hand, if you say his DNA was at the scene, so he's obviously guilty, you're kind of the reverse of this rube I just described above, a yin and yang of lack of reasoning. In reality, DNA, including touch DNA, or I think it's fair and more accurate to call it trace DNA, and you'll see why, it can be material and even critical circumstantial evidence in a case for or against a defendant. You have to understand how much confidence you can put in the evidence itself, the DNA recovery, and then how it fits into the circumstantial picture. The DNA is not an answer in and of itself. It's just circumstantial evidence. So if a lab reports a match or a probability of random match that's so low that it can safely be called a match, then you need to assess that. What are the probabilities here? Did the lab conduct the test accurately? Did the technician follow protocol? Could something else have introduced the DNA during the testing process? Was it a mix of profiles? One time there was a court that didn't allow trace DNA when it was a mix of 3 people and the person they were trying to tie it to was only 7%. And that made the rounds on some social media articles. What didn't make the rounds was that the Sixth Circuit Court of Appeals reversed the judge there and said, no, you need to let that evidence in. You can cross-examine it. But still, some judges will look at this and say, if it gets too attenuated, then I may not allow this evidence in, and I get that. How fragmentary is the profile? Is it solid or just partial? There was a case in South Carolina where the expert said, I can cut this down to 1 out of 2 people, 50% of the population. And the court there said, no, it's not going to get it. That's not really probative for the jury to say that, half the world's population could have left this DNA is not really doing anybody any favors. So it's possible to identify a procedure or a result to identify a profile that is so attenuated that it could be excluded from evidence. But if those kind of problems are paramount, that evidence is coming in. And generally speaking, this evidence is allowed. No matter what anybody tells you, generally speaking, this is allowed. And research it yourself. And finding one case in the United States where a court excluded it, or a few cases without reading the details of why it was excluded, could lead you astray from understanding that generally speaking, this evidence comes in. Now, again, this evidence isn't the answer to the case. That's what we're going to go over. So the weight of the evidence is for the jury to decide, generally speaking. All right, so we've cleared that hurdle. This evidence is likely to come in unless there's some kind of flaw with the sample or the process or whatever. So if you have some confidence in what was represented to you as evidence, that this DNA was there and that these odds are right, the process was conducted correctly, what does it actually tell you about what happened? As I've said already, I think more than once here, and I keep saying it because it's not a well understood concept, DNA is generally circumstantial evidence. Does the DNA at the scene really mean the defendant was there at all, just because the DNA was there? Does it mean the defendant was actually in contact with the item at a relevant time? Could someone else have put the item there without leaving their own DNA? Could someone else have inadvertently transferred the defendant, or on purpose, transferred the defendant's DNA to the scene? So these things matter a lot, right? They matter a lot to how important this DNA evidence is if you conclude it was there. That could place a solid DNA result into the realm of the final nail in the coffin of guilty, or not really important at all. If there's an equally valid reason why the DNA could be there without implicating the defendant, as there is implicating the defendant, and that wouldn't help you at all then, right? So in this video, we're going to look at some of the possibilities and whether the DNA as found, at least as we know it, and that can certainly change, whether that suggests one possibility more strongly than others. Once you disregard trolls who pretend DNA evidence isn't important, you get to the serious issues that actually do exist with such evidence. For one thing, and this is important, DNA from one person can be transferred onto an object by someone else, secondary transfer. And secondary transfer is an important concept. The failure to understand it can lead to completely misweighting DNA evidence, either to the detriment of a potentially innocent defendant or in letting someone who's guilty go free just because you didn't understand what was going on. And here we're going to look at an interesting study that I've mentioned in a couple of videos that shows how DNA from one person can be transferred to an object by somebody else. Now, the study we're going to look at involves somebody taking in hand a knife and stabbing a box that had foam in it 5 times. Okay, so that you have to hold the knife pretty tight and you're jabbing it in something 5 times. Then the person puts the knife down onto a DNA-free surface, and then they put their hand onto a plate. Then another person does it. Same thing. Pick up the knife, stab, put their hand on another plate. And you do that until you've had 4 people stabbing with the knife, handling the knife, and then touched separate DNA-free surfaces. Now, obviously, what will be interesting here is whose DNA is found on the knife, and perhaps more interestingly, whose DNA is found on the clean surface touched after handling the knife. If the 4th person touches a clean plate and it has DNA from these other 3 people, 1 or more of them, that's secondary transfer. Those people never touched that plate. But if you just looked at the DNA and you didn't understand that, you might believe that they did. So if the 4th person leaves DNA from one of the earlier knife handlers on the clean surface, it only could have gotten there by picking up the DNA from the knife and then from the other person by handling the knife and then transferring it to the surface. And in that case, we would have DNA from someone who never touched the clean surface present simply because that person had earlier touched something later touched by somebody else. And this is really important. This is secondary transfer because it creates evidence that can suggest a person was in contact with an object when they were not. The implications of that are that you cannot simply assume DNA on the surface of an item was deposited there by the person whose profile matches. You got to look deeper into it. You have to look at the circumstances to see how it happened and to reach the most probable conclusion or exclude ridiculously improbable conclusions. Let's see how the study went. How'd they do it? I've already mentioned this before. They had 4 people in sequence pick up a knife, stab a box with foam in it 5 times. They put the knife down on DNA-free paper. Then they make a palm print on a DNA-free surface. And they do it again on another surface. And they keep doing this. The stabbing of the foam is meant to make you have to hold the knife tight and have a little bit of friction, so there'll be some DNA transfer likely. And here's a picture that shows how they did the study, what the sequence of things were. They conducted this test 6 times using a different group of 4 people each time. No person could be in the test more than twice, and if they were in it twice, they had to be in a different sequence. There are several interesting results from this test. One thing to keep in mind, in the real world, DNA is not always collectible from a touched surface. I mean, that sheath that was found at the scene was certainly held by somebody at some point. They didn't recover any DNA from that. They only got it off of the snap. So different surfaces can collect DNA in different ways and preserve it in different ways, and people shed DNA at different rates. So the amount of DNA a person leaves depends a lot on the person, what they're doing at the time, and what it is that their DNA is coming into contact with. So the knife first. You could see from the test results that the last two people to handle the knife always amounted to most of the DNA collected. That shouldn't be surprising, right? They're the most recent people there. You can also see there was always at least some DNA from each participant at the end of the test. The last two people comprised most of the DNA. There was always some DNA from that first person there. The subsequent handling of the knife by the later people, it never fully erased the prior DNA contributions. And you can also see the amounts varied, which, among other things, goes to show that different people contribute DNA at different rates. And that can be important too. This is really interesting. And it does show, I think, the importance of finding a sole source DNA sample. The most recent person to touch the surface generally left more DNA to recover, but if someone else touched the surface, their DNA was still present. The implication is that if only one person's DNA is on the surface, it's likely that just one person touched it at any recent time, or that DNA came from the last person to touch it. Because in none of these cases were past contributors erased, and they wouldn't be, I suppose, unless it was cleaned. And in that case, again, the most recent DNA would be the person. It doesn't look too good for Coburger in terms of his DNA being the only DNA found on the knife sheath, meaning that he's likely the most recent contributor of that DNA if it was directly handled. We still haven't talked about secondary transfer, and we're going to get into that because that's also interesting. But again, at least as far as the state says, Coburger was not the dominant DNA sample. He was the only DNA sample. So it's not a mix of people. There's not Coburger and somebody else. So far as the state has to say, right? The defense will have to deal with this. Again, they can't laugh it off like social media. They're going to have to actually deal with this evidence. So the evidence suggests that if Coburger was in direct contact with this knife, he was likely the last person to do it, unless, of course, somebody handled it just with gloves after that. And again, that's circumstances. And you have to look at that. Now let's look at the really interesting part of the study, which is DNA transfer. And that's where this kind of touch DNA versus trace DNA conundrum comes in, because in the old days, you'd think touch DNA was, if my DNA is on something, I touched it. But that's not true. Your DNA can end up on things just because you're near them, or because someone else transfers your DNA there. And I'm not saying that happens on purpose. It's a natural process, happens a lot. And you're going to see that in this study. So here we're looking at DNA left on a clean surface after handling the knife. And as you look at persons 2 through 4, you can see that typically the last person to handle the knife leaves the most DNA on the next clean surface. But you also see that sometimes the person brings along or transfers DNA from an earlier knife toucher to the new surface. So person number 4 does all the stabbing. 3 people have touched the knife before. Then person 4, who didn't make any contact with these first 3 people, touches a plate that these first 3 people never touched. And some of those first 3 people's DNA ends up on this plate. That's secondary transfer. So that means your DNA can end up on a surface you never touched just by virtue of someone else touching something you did touch and then touching the new surface in question. All right? And so we get that. So you touch this, somebody else comes along later, touches it and touches something else. Now your DNA is over here and you never touched that thing. That's secondary transfer. Now, note in all these cases, though, the person who actually touched the second surface, even if they transferred an earlier person's DNA too, left DNA on the new surface. There are no examples in this test where someone left a sole source sample from an earlier person. They always left at least some, and generally more, of their own DNA. So what I'm saying, it's not the case that somebody handled the knife and then put their hand on something else and left none of their own DNA, but only the earlier person's DNA. That didn't happen in this study. And that's why it's important, I think, that they're saying that this is a sole source match of Coburger. It's not a mix of DNA. They're indicating here that it's unlikely that it was secondary transfer. Now, again, the defense has to have their say on that, but that's the importance of it being sole source DNA, at least as I understand it from observing the study and reading some other things. So this suggests it is highly unlikely that someone touched something Coburger left behind. I've heard, well, he grades papers and maybe somebody touched his graded paper or whatever, and then left Kohberger's DNA from the graded paper on the knife snap without leaving any of their own DNA behind. That didn't happen in this study. Now, there is a significant study where people shook hands together for 2 minutes and then one of them touches a knife. And in some cases in that scenario, a sole source sample was sometimes detected in the minority. That was the person who did not touch the knife. So it can happen, but on the other hand, that study scenario seems extreme, to put it mildly. People shaking hands for 2 minutes, you got a heavy sweater or whatever covers up the other person. I think the study I'm talking about is more realistic. The person, because Coburger's not sitting around shaking hands for 2 minutes with the person who ends up being a murderer. The excuses you hear for the secondary transfer, which are reasonable things to think about, are somebody touched an item that Coburger earlier touched and then transferred Coburger's DNA to the snap on the sheath. And that's something that you should think about. What I'm saying is the study that I'm looking at suggests when that is the sequence of events, it's unlikely that the sole source sample found on the second item would be from the earlier person who touched it with none of the second person. And that's bad for Coburger. Of course, you can imagine someone was out to get Coburger and got his DNA from somewhere and smeared it on a sheath. Yeah, you could make that up if you wanted to. You could imagine something less crazy, like Coburger touched something and then that thing touched the snap and just got smeared all over it and left the DNA on it. The real murderer somehow got their K-bar sheath in contact with Coburger's DNA by accident and took home a graded paper or whatever, and it smeared it all on there. But yet the actual person that would need to snap it, they didn't leave any DNA on there, right? So you could think that, but that's stretching the realm of reality, I think, on into imagination from that standpoint. From a circumstantial evidence standpoint, the sole source DNA, if that's what it really is, on the snap was most likely left there by the person who matches the profile, because that's the only DNA there, and it makes sense to secure a knife into a sheath that you press down on it. Now, that implies that Coburger, or whoever did this crime, made a mistake, a couple of mistakes. One was touching the snap in the first place and not cleaning it off. And then the second is somehow dropping it at the seam. So you could imagine, well, he wouldn't be that dumb. Someone must have planted it there to frame him. You can run with that. I mean, I hear you. Explore that if you want to. But the most likely scenario, not one that concludes beyond a reasonable doubt by itself, is that by pressing down on the snap to secure the knife in the sheath, someone left their DNA on that. And the person who left it there was Coburger, because it's his DNA. That's the most likely scenario. Now, something that is interesting is the defense raised a very good point of an apparent lack of evidence in Coburger's vehicle of any connection to the victims. And if that stands to the degree you'd expect to see evidence like that there, the lack of that supports the defense. I don't weight that too much personally, because of the preparation an intelligent murderer could have taken to prevent or limit evidence from making it onto surfaces inside the car. In other cases where people murdered someone and got away in a vehicle and didn't have DNA from the victim in the car, that does happen. And he had weeks to clean the car. But still, it's smart of the defense to raise the issue, and the prosecution will have to deal with that. But you know what the defense didn't raise? That they did say in there, hey, we didn't see any DNA related to the victims in the car. You know what they didn't say? He didn't own a K-bar knife. They didn't say Coburger never owned a K-bar knife with a leather sheath, which is one variant of a K-bar knife. So how many people own a K-bar knife? It's a lot, I grant you. And how many own it with a leather sheath? That's still a significant amount of people. But if you never owned it, that could be a pretty good defense to it being yours left at the scene, right? Maybe Coburger had visited a friend who had one, played with it a little bit and snapped the sheath, and then that person put gloves on and went and murdered somebody. So I think if he had never owned this knife, that would have been a good one to slide on into the filing, all right? It would have been even better for the defense if they said, well, okay, so he did own one, but look, the state found it during the course of the search. It strikes me that in addition to the state being able to say with scientific certainty that Coburger's DNA was on a sheath, now how it got there, the defense can contend, they are also going to be able to say, we can show he bought a knife with a sheath like this. I mean, the search warrant returns from Amazon and stuff are under seal. I feel like this is coming. And it was not in his possession anywhere after he was arrested, because you didn't see that on the search warrant returns. And that's just supposing a little bit, of course. But if they are able to show that he purchased a knife like this, doesn't have it anymore, and his DNA is on the sheath at the scene, the imagining that this doesn't matter is going to get tougher to do. Now, maybe that doesn't happen, right? Maybe they can't show that he ever had a knife like this. I'm not sure that we know that because so much stuff is under seal. But whatever, I just think it's interesting that the defense has not laid out there that he never owned a knife like this. Because I could say that I didn't own a knife like that. I had a K-bar, but no leather sheath, and you're not going to be able to find anything that shows that I ever bought one because I didn't buy one. So whoever sheath that was, it wasn't mine. That'd be pretty sweet to be able to say that, right? But it wasn't said. Now, if the story is he owned this knife that only so many people have, it's gone now. The matching sheath was found under a murder victim with only his DNA on it, then the conclusion from the story is it was his knife and a sheath was found at the scene because he dropped it there for whatever reason in a struggle. And it's all supported by all the other circumstantial evidence. That's the state's theory, right? Now, maybe he has a story that, yes, I did own a knife like that. And it was in my car with my phone. Somebody took my car that night and brought it back. You'd have to test that story against evidence and reason, right? If we're talking about making up excuses. Or I sold the knife to a guy a couple of days before the murder, and he was wearing gloves when I sold it to him. And he drove a white car very similar to mine. You'd have to test that against evidence and reason too. And anything like this, which none of the defense has proposed yet, is fair because, again, the DNA is just circumstantial evidence. And while it can implicate Coburger, you have to look at whether there are reasonable explanations that don't implicate Coburger. And you need to think about that if you're on the jury or if you're thinking about the case, but also the defense can bring that up as well. They just have not yet. That seems somewhat informative to me, but not conclusive because maybe they'll bring it up later. But so far, they haven't disputed ownership of a knife like that, which you'd think would be fairly material. But the fact is, whatever evidence the state is developing during its investigation after the arrest and initial search warrants, well, that's not public. Same for the defense. It could be nothing on either side or something really important. All we're getting at this point is what they slip into the filings. But the fact is, sole source DNA is a big problem for the defense because it is a material piece of the circumstantial evidence puzzle. If you cannot look at the evidence overall due to mental limitations, or you think imaginary fantasies are substitutes for logic and reason, then you may not see why it's important. But as defense team, you can bet, don't suffer under any such mental limitations. That's why they're already working with experts to try to find strategies to contend with this evidence. They could gamble on an idiot being on the jury because that does happen, and the internet proves they're still out there, but that's not competent lawyering. His defense counsel knows that juries are not supposed to include fantasies in the concept of reasonable doubt. That's the reasonable part. And they will work inside legitimate issues regarding circumstantial evidence. So they may contest the accuracy of the test. They may want to conduct some test of their own. And they certainly will contend what this evidence means in the overall circumstantial picture, that there can be other ways that this DNA got there, as we've already discussed. That's what they'll do. They won't just say, well, we don't have to worry about it because it's dumb and it's bogus and it's junk, because it is going to be led into court and they're going to have to deal with it. Now, if they were to waive all those logical things off and go for pure fantasy and hope for an OJ jury, then they've given up hope except for the idiot wild card. I don't think that's going to happen. I think his lawyers are better than that, and he has a pretty extensive team at this point put together with at least a couple of experts working with his attorneys on DNA evidence, and that's because they know that it is important. It is important. His DNA was found at the scene on an item associated with what's going to be the murder weapon. So you got to deal with that. But in fairness to their side, if you think this evidence is important, importance doesn't mean conclusive. And I think we've covered that in this video, in that you look at what this evidence is as part of the overall circumstantial picture. And you can look at what else the state has. The phone pings, which again, those aren't conclusive either. And his car on videos, which are pretty suggestive, at least the ones leaving out of where he lives and coming back. But again, you can contend all that. But you look at the overall picture of evidence and you say, well, I don't find that compelling. Well, I hear you. The state would have to do more to convince me, or this, that, the other. I get all that. If you say none of that exists, or none of that makes any difference because each piece of evidence by itself doesn't establish guilt beyond a reasonable doubt. That's not really reasoning there. That's just supporting a conclusion you have with nonsensical statements. So that's what still makes this case interesting, is there is a piece of evidence that if it was legitimately dropped by the murderer, was not something that was intended to be left there, which was an item associated with the murder weapon. And then it has the defendant's DNA on it. So that's very significant in relation to the other circumstantial evidence they have. But because of the way the case is, and I think that's fine and it's fair, whether the state has more evidence that might sway more people who might be on the fence, or the defense has something to say about that shows the state's case is weaker than you think it is, we just don't know that stuff right now. So I'm only looking at it from what we see in the public eye. And from that, I can say, yes, they clearly had probable cause to arrest this guy. And in my opinion, I think they probably got the right guy. But this would not be the right time to put a jury into the jury room and vote on whether he's guilty or not. We haven't seen all the evidence, and we haven't even seen the witnesses testify to the evidence that is there and heard the defense's counter arguments to that. And that's when you should make the final judgment. It's really interesting what science can do, and it's really interesting how the results of science can be misconstrued, potentially to the detriment of an innocent person or for the help of a guilty person who doesn't deserve to be free. And so you need to put your mental firepower to it to look at the whole picture of the case, and the forensic evidence just being an element of that. Well, that's it. Thanks. Bye.